The question is that the motion be agreed to.
Mr Speaker.
The Honourable Phil Goff.
Mr Speaker, the Labor Party supported the first reading of this bill when it was introduced to the House, and we followed the submissions through the Select Committee very closely. And they were interesting submitters because they ranged from one side from the Sensible Sentencing Trust, and the Sensible Sentencing Trust basically doesn't believe there should be any parole at all, that everybody should serve the full sentence to the last day of the sentence and then be let out, to other groups like Rethinking Crime and Justice, Kim Workman, a former Deputy Head of the Department of Corrections, and it's fair to say that they wanted probably a much more liberal approach to allowing people to be released as quickly as possible. Among these submissions, and I think the most important submissions, was the Parole Board itself, and the Parole Board provided a private submission, and I want to thank Justice Gendel and Marion Frater for appearing before the Select Committee, but I want to thank them for something beyond that. They actually issued an invitation to us to sit in on actual parole hearings at prisons around the country. And in 6 years as Minister of Justice, I'd never done that. And I've got to say it was, for those of us on the committee that sat in, it was a fascinating experience. I was at the Auckland Women's Prison, and there were cases, people that were there that were sentenced to life imprisonment for murder. And it was interesting to see the way in which the Parole Board operated. And I've got to say it gave me some confidence in the Parole Board. And I have to say that everybody that appeared before the Select Committee congratulated the Parole Board on the way that they conducted their hearings and the way they did their job. So I want to put on record to the House, you know, it's not an easy job being on the Parole Board. If you get it wrong, and inevitably, when you hear thousands of cases, from time to time you will get it wrong, you cop a lot of flack. But I believe, and from what I saw, they did their job very professionally, and professionally and in a humane way. But they weren't a soft touch, having said that. So, as a result of those hearings, the Select Committee was in support of the thrust of this bill, with some changes that are significant but not major, and also, Minister, with a recommendation to you. And I hope as the new Minister of Justice you'll look at that. And the recommendation related to a particular area that the Parole Board brought to our attention, that they often did not get information from civil courts on civil protection orders that were relevant to their hearings. And that was a real worry to us, because the Parole Board is as good as the information that it gets before it. So Minister, we've thrown the ball back into your court. We haven't held this bill up, but I would urge you to very seriously consider the recommendations of the Select Committee, which were bipartisan recommendations, just so that there is an automatic supply to the Parole Board of civil protection orders where that is relevant to the cases that the Parole Board is hearing. I think that would help them, and it provides, as you mentioned, additional protection to the victims, and we should always be doing that. Mr Speaker, it is a controversial area, parole, and it's controversial because there are people who, when given parole, will reoffend, and occasionally they reoffend seriously. And whenever this happens, the natural reaction of all of us is to say, how the hell did that happen, and is the parole system working? Well, I think we've got to make the system as good as possible and to minimise the risks that are posed. And it's not an alternative simply to say there is no parole. Why is it not an alternative? Well, it is an alternative if the government wanted to spend hundreds of millions of dollars, maybe billions of dollars, in forcing everybody to serve their full sentence. And that would mean this: it would mean the majority of people who are released on parole, who don't reoffend, would be required to serve the full sentence. And that seems to me to be reasonably futile. But there's an even stronger argument than that. All of the international studies that have been done on parole demonstrate quite clearly if a person serves their prison sentence to the last day and then is released, they are much more likely to reoffend. The best way to minimise reoffending is to release early and to release on conditions. So people have to turn up to their probation office, they have to meet conditions about where they live, who they work, who they associate with, and they know that when they're released, that if they do something wrong, there is that power of recall, almost automatic if you offend seriously. The parole system by and large does work. But I've got to say that when I looked at the parole system as Minister in the early part of the last Labor government, I was really unhappy about the level of reoffending on parole. And we made major reforms. The Parole Act 2002 really did turn the system around. And I was very pleased to pick up the regulatory impact statement for this bill to see what they said about a piece of legislation that was my baby more than 10 years ago. And actually, I was really pleased because they said it had been particularly effective as a piece of legislation. It acknowledged that what we did was to make for the parole board the paramount consideration, the safety of the community. And that should always be the case. You know, don't keep people locked up who don't need to be locked up, but your paramount consideration is the safety of the community. And we put in a clause, a particular clause, I remember debating it with the Ministry of Justice at the time, that the release of a prisoner must not pose an undue risk to the public. And that's the principle that the parole board works on. And as a result of those changes, yes, there were a greater number of individuals who served a greater proportion of their sentences. That put a bit of pressure, as some of my cabinet colleagues from those days will remember, on our prison system. But what did it achieve? And this is where the regulatory impact statement on this bill is particularly interesting. It said the number of offences committed by prisoners in the period between release on parole and the end date of the sentence halved. The number of people who offended halved, and on a different measure, the harm done by that offending also more than halved. So I can stand up in the House today and say with a great deal of pride that a piece of legislation that I sweated blood over at the time has been effective, and by and large it stood the test of time. But over a 12-year period, of course you learn something from the experience of the Act. And I think it's sensible to review any piece of legislation, and the government has done that, and the recommendations of the Department of Corrections were to actually change one aspect of the bill that said that when you came up for your parole date, whether or not, if you weren't given parole on that occasion, you had to be seen again within 12 months. Now, there was a problem with that, and the first problem was that, you know, most people have to do 3 parole hearings before they're released. And actually, often the first 1 or 2 of those parole hearings are just formulaic. Everybody knows the inmate is not going to be released. Now, what does that do? Actually, let me give you one other statistic. A third of the inmates have at least 4 parole hearings or more parole hearings before they're released. What does that do? Well, first of all, it takes up a lot of time from the parole board and adds to the cost. But that's not, to me, the major element. The second thing it does is that if it's a serious offence, for the person who is the victim of that offender, they are notified, as they should be. That was part of my legislation. But it causes, in some cases, concern, in other cases, major trauma. So if you're not going to release an inmate, and everybody knows it, why put the victim through that process? And for the offender, him or herself, it means false hope, because you're not going to get it, and that just leads to frustration. So it's estimated that this will cut parole hearings, which have run up to about 8,000 a year last year, by about 800. But the important thing, the Corrections Department said this will not increase the length of time people spend in prison. And Minister, you might be interested in what the Parole Board said, because the Parole Board ventured the opinion this change will actually cut the amount of time that people spend in prison. Because often, you know, you go up to the Parole Board, but it just simply is an interruption in your programs for rehabilitation, which you haven't completed. Till you've completed it, you can't do it, and that means you're turned down, you have to wait a full further year. Under this legislation, actually, when you've completed your programs to the satisfaction of the department, the Parole Board has the power to bring the Parole Board hearings forward, and you can be released earlier. And I think that's a really sensible idea, Mr Speaker, and I think that this will make the legislation work well. There are some set out in the report back to the House. There are set out the changes that we've recommended. They have been agreed by everybody. I think they should go through, and the Labor Party will be supporting the second and subsequent readings of this piece of legislation.
Mike.